Good afternoon, everyone from IARC. We're delighted to be hosting this webinar series on legal, ethical and governance aspects of exposome research. Today's webinar is sponsored by the HEAP project and the International Human Exposome Network. The topic is pseudonymised data in the GDPR, insights from the latest decision by the Court of Justice of the European Union. We've had a lot of interest in this webinar, many advanced questions submitted and nearly 500 participants registered. We'll do our best to approach this complicated subject in the time available. The aim of the session is to explain the general considerations arising from case law, focusing on when data are personal data or non-personal data under the GDPR, and also to look at how this issue is considered under the EHDS. Our presenter today is Evert Ben van Veen. Evert Ben served as the legal expert for the HEAP project and chair of the Ethics and Law Working Group of the European Human Exposome Network. He's a lawyer with 30 years experience in health and privacy law, and his legal research focuses on privacy and data protection in large-scale research consortia. Before I hand over to him, a few housekeeping points. You can use the Q&A during the webinar. It will be visible to the panelists. We will select a couple of topics to be addressed at the end. You can provide feedback through a survey that you'll see on your screen after the webinar closes, and you'll receive a follow-up email with background information and Evert Ben's contact details. A recording of this webinar will be available on the HEAP YouTube site following the webinar. It's currently being streamed live there as well. Evert Ben, thank you for joining us. The floor is yours.
Thank you very much. Yes, like Heather told you already, we have a very large audience. And apart from the length of my slides, that regretfully means that we have very little interaction. But later, perhaps, there can be supplementary answers in the feedback. Then the second point, before I start, is that the audience is also very diverse. There are lawyers, ethicists, perhaps statisticians, and of course researchers. And well, the emphasis is really on the legal aspects, but I still hope to give some valuable insights to the researchers. And lastly, then, for the introductory remarks, that some slides are rather text heavy, so I don't disobey the laws of good slide making, but as later the slides can be used as a reference, I thought it would be better like this, and sometimes I skip some of the text. Okay, let's start. The outline is as follows, and the outline also has certain spoiler alerts, because after an introduction I will talk about pseudonymized data in general. And the outcome is that pseudonymized data are not by definition personal data. Then to substantiate that, I'll discuss two concepts of anonymous data, and then the case law by the European Court of Justice by personal data, when data are personal under the GDPR and when they are not. And then I'll go into depth of that case, which is now the start of this webinar, the SRB, which means Single Resolution Board, and the European Data Protection Supervisor. Then, as Heather mentioned already, I will discuss the concepts under the EHDS, and I can tell already now that I don't think they are consistent with the GDPR definitions. And then we delve deeper and go to the research area. When would I at least consider pseudonymized data also anonymous in a research context? And I'll discuss the consequences for research. So, introduction then. As a researcher, you want to find patterns between exposure, disease, treatment, and outcomes. Perhaps not all at the same time, but certain aspects of that, like disease and disease and treatment, and outcomes, or exposure and disease, etc. And this is the only funny picture which I have, by the way. a picture as on the left won't help you with that. Huh? You want to know who the person is behind all these variables. So it will always be individual level data. And that is where pseudonymization as a privacy enhancing technology came in. And it has really a long tradition. It is not that privacy enhancing technologies have been invented in the last years under the GDPR. It already was there much earlier. And in the latest version, which will be sent around, I'll give some references. But originally we didn't call them pseudonymized data, but coded data. So here and after, it's always about individual level data. And they often have a number, such as patient number in electronic health records. But with pseudonymized data, we have a chain from the original individual level data to a separate data set under the pseudonym, which I then call in the further slides a P. And from there we can make further distinctions about the pseudonymized data. Pseudonymized as in the ISO norm, which I won't discuss. Pseudonymized with the same entity. Within the same entities, some university hospitals have a separate research environment, and it will also be pseudonymized the data before they go, the patient data before they come into that research environment, also not discussed here. It is about pseudonymized data from a data source to a different entity. And then we have to taste pseudonymized data in the sense of the GDPR, which then also are personal data, and pseudonymized data which are not personal data in the sense of the GDPR. Of course, those latter two terms are exclusive. And yeah, well, you will know that already. Pseudonym can be applied when data from different sources and different patients are combined. You still must have individual level data, but it is even more important, and it will also get, how do you say that, more difficult or more intricate to make that pseudonym when you have different data sources with the same patients. And want to combine those. And when you do the follow-up of a patient, or patients are treated in different hospitals, then the same patients, then you want to do that. And some kind of common denominator, the same common denominator must also be used when you use multi-party computing or federated analysis, which we won't discuss here, because here it is combining data at a recipient still on an individual level data. But the concept having a common denominator for different for the same patients in different settings still applies there as well. And with those privacy enhancing technologies and a pseudonym, data were often considered anonymous. Those statisticians often disagree, and many lawyers as well. And it's not really a recent debate. I found an early publication of mine of 2003 already. Then we called it coded data in scientific research, and I tried to sort of clarify the concept, also stating that they're not by definition personal data, and that depended. And so we had already this long discussion, and then came the GDPR, and many thought that that settled the discussion whether pseudonymized data are personal data, because the GDPR has, apart from a definition of personal data, which is basically the same as was in the original directive on data protection, also has a definition of pseudonymized data, which is very long, but it says it's processing of personal data where, so to say, the link to the direct identifiers is kept separately and subject to means so that the direct identifiers are not in the hands of the same person, become in the hands of the same person as the one who processes those pseudonymized personal data. So many read in that pseudonymized data are also personal data, always, and discussion. Only a few disagreed, which me, of course. And then came the decision, other spoiler alert, of September this year, where it was stated pseudonymized data are not by definition personal data, and whether the data which carry that label pseudonymized are anonymous data must be decided on a case-by-case basis. So then we get to what does that mean, that case-by-case basis. For that, I'll discuss the case law, but first I want to make a small clarification. There is a difference between the statistical concept and the legal GDPR concept. In the statistical concept, it is almost always about absolute anonymity, excuse me. Can anyone, whoever, re-identify the person behind the data? And of course, that is made much easier when there's still individual level data, instead of aggregating statistics. And for that, then there's still a danger with the variables combined, in that for that we have statistical non-disclosure techniques, which are used by our national statistical agencies. And the legal concept of non-personal data, personal data, is different. It is about the explanation of the terms of the GDPR, and as any legal explanation that is value loaded. It is not counting or whatever you do with statistics. It is finding the proper legal solution to a societal problem and the background of what the GDPR aims to do, namely fundamental rights protection. And so some, actually many, wanted a very broad interpretation of the concept of personal data, nearing actually the statistical concept. And that was done, for example, in Opinion 5/2014 by the predecessor of the European Data Protection Board, which is all the national data protection authorities together, called the Article 29 Working Group. And that gave a very, very broad interpretation of personal data. And that met with criticism, for example, by two statisticians already. But still it was used quite a lot by that EDPD, and I saw to my surprise that it was even used in the recent TEDAS paper on data minimalization. Because it was not accepted, to my surprise, because it was not accepted by the court, which is actually the ultimate decision maker, the Court of Justice of the European Union. It has become a relative concept, another, spoiler breaker, which I will now discuss. So legal versus statistical. Legal is relative, but the statistical concept is still important for open data, as to publish results of research, because then it's uncontrollable what will be done with the data, and so you must have these statistical non-disclosure techniques to assure that no one can really find the person behind those groups which are together in these statistics. And the legal concept is about means likely to be used to re-identify, taking into account objective factors as cost and money. And that is, to a large extent, context dependent, so also controllable. Because in the case law, these are the cases which I will discuss, there is this background of fundamental rights protection, and then in some meant, like the working party earlier, and many lawyers actually still, a narrow concept of personal data would mean less fundamental right protection. The court has used this reasoning for other concepts of the GDPR, but not for the concept of personal data. And actually, the Advocate General, that is a learned lawyer who sort of issues an advice to how to decide for the court, and can go a little bit deeper in the literature, warned against the concept of personal data becoming indefinite. And the Advocate General did so in the Breyer case, which was the start of the series of court decisions on personal data. It was decided under the previous directive, where also that opinion was issued under. But like I mentioned, it has the same definition, or nearly the same definition. Only two words are different in the recital. And the question there was, are dynamic IP addresses also personal data for the Internet Media Service, which sees you using that service via your IP address? And the court said not if identification of the data subject is prohibited by law, mind, come back to that when we discuss the EHDS, or practically impossible on account, blah, 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 disproportionate efforts in time, cost, and manpower, so that the risk of identification appears in reality to be insignificant. And I'll use that word insignificant later as well, as a sort of abbreviation of all which comes before. The court also said that not all information to re-identify needs to be in the same hand. It can include the help of a third party, but still for that internet media provider, such as by the IP provider, which issues the floating internet addresses in the case of cyber attacks. It was, by the way, in this case, the fact. So in this case, they were re-identifiable because the internet media provider could go back to the internet provider, the IP provider, in case of a cyber attack. But the lessons are, what can be personal data for one party does not need to be personal data for another party. And the risk of re-identification does not need to be absolute, but it is either forbidden by law or insignificant. So, and this led, we had this discussion in literature about the absolute approach and the relative approach. This led to many lawyers, not all were convinced, by the way, to a confirmation of the relative approach, which has then two aspects. Two aspects of this relativity. Data can be re-identified for some, but can be anonymous for others. And the risk of re-identification does not need to be absolutely eliminated if it is not already forbidden by law, but must be in practice insignificant. I'll come back to those two aspects later as well. Now, a little sidestep, this is, the Jehovah's Witness was not about what is the concept of personal data, but more who is the controller of personal data. And controller is a key GDPR concept. It's the entity which determines the purposes and means of processing of personal data, or entities together, and then you're joint controllers. The controller is responsible for GDPR compliance, and these Jehovah's Witnesses, the local chapters or whatever you call them, go from door to door and try to convert you, or which usually does not work, but anyhow, for some, yes. And the national organization does not receive the personal data about the houses visited. So, for example, whom not to visit anymore. And then the question was the national organization still a controller? Yes, said the court. The concept must be interpreted in a broad way. So here you see a broad interpretation of a certain GDPR concept. And you can be a joint controller also when you do not have access to the personal data. And that has been upheld in later decisions. And the court then clarified that it does not mean that all the data processing by all these joint parties are common, or the parties together are falls under that joint controllership, but only there where the purposes and means of the parties coincide. And in this case, I agree with that broad interpretation, because if it is personal data, then someone must be accountable. Though we also warned against going into extremes in a paper of joint controllers in large research consortia. Now, the VIN case, which was in 2023, yeah, and especially for the lawyers, I discussed this case, and the background is very complex, and but it means every car or truck has a vehicle identification number, which is yeah, stamped into the machine somewhere by the manufacturer. And now the European Union wants to have a sort of free market of goods and services. So it had made a regulation that manufacturers must make available to independent garages under that VIN, so they can look the car under that VIN, which spare parts are available. So that not only their dealers would have that, but also independent garages. Well, I've seen, not read, but I've seen a lot of case law about that, because apparently manufacturers don't like that. They must be so transparent and can be how do you say it, can have competitions from independent garages instead of their dealers. But one, I found something new, namely, and then that is what interests us. So under that VIN, they are personal data. That VIN is actually personal data to the garage, and I have no legal basis to disclose that. Well, the court says yes, you do, based on the spare part regulation. You must make, so that is an obligation by law, Article 6(1)(e), I think, that you, even if it were personal data, you must make them available. The court says that use the second aspect of the relativity test, whether the garages can indeed re-identify persons under that VIN, which the courts didn't decide, because the courts give advice to the lower courts, who refers that case to the Court of Justice of the European Union. So that was for the court to decide. But then it also said, and indirectly, if it are personal data for the garage, then indirectly for the vehicle manufacturer, it also becomes personal data, even though it were not personal data for them originally, because they sold the car not to a natural person, but to or a truck, but to a company. So the first is not so surprising. But the second is, because the first aspect is when personal data for a releasing party, or what are personal data for a releasing party, may not be personal data for a following party. But now the other way around, it is different. When a data is personal data for a following party, that makes it also personal data for the releasing party. And that's quite a paradox. And a Dutch professor in data protection law says, yeah, so this is a breach of the relative approach. And she will give a lecture about it by the end of this month, so then I will hear more why she thinks that, because I haven't seen another application of this novelty. And the first aspect, only the first aspect, personal data for A and not individual, and not by definition personal data for the following B, is corroborated in the SRB decision. And our use cases are also about that, so not the other way around, but A, personal data, and perhaps not personal data in the following research environment. But yeah, this paradox must be solved, but that is more a lawyer's paradise than it should bother you. Then EAP. I will be very brief about that because it was very recent. But what EUP Europe, that is the trade organization of people doing digital advertising, and that is a lot, and it has a huge turnover, that digital advertising. What it practically means for you is that if you have visited the website for example, dog food, that is the example used by the Belgian court, and you hadn't paid attention to click or to refuse all cookies, then the next time when you visit a completely different site, like a journal, you see dog food ad. Quite a nuisance. Now, the Court of Justice held that EUP was a joint controller together with its members because it organized all this. It also said that the essence of the GDPR is to ban such behavior unless there is a good legal basis. The Belgian court in this year, actually, spring this year, endorsed the relative view, and because that must then the Belgian court, based on the answers of the Court of Justice, must then give the actual decision with a practical decision, which then can be executed in the national system. The EAD can back to the IP address, so it also processes personal data more or less directly. And that is then a consequence of when you are a controller. So the EAP was responsible for all further GDPR compliance, like the security of the processing, which they hadn't had. They had to do a data protection impact assessment. They should have a DPO, etc. They had none of that, so they were also fined for that. And now finally, then the decision, which is the start of this webinar, or at least not the start, but why we have this webinar. The SRB is the single resolution board, and that acts as a body under European law to handle claims after a bankruptcy. Didn't know that, but now I know. And the EHDS comes then in, the European Data Protection Supervisor, which as the supervisor authority, because we have national supervisory data protection authorities, and we have one for the European Union that is called the EDPS. And what had the SRB done wrong in the eyes of the EDPS? It had sent certain files of claimants to Deloitte under a pseudonym to assess whether it had dealt with the claims fairly. So I wanted a second opinion from Deloitte. And the EHDS stated that it had sent personal data to Deloitte without a proper legal basis to do so, and neither would have had Deloitte then. And originally it had fined SRB, but that fine was later waived because the EDPS admitted that, well, the SRB had done a lot of privacy-enhancing technologies. So yeah, in the end, the breach was not so severe, but still it insisted that these pseudonymized data were personal data by definition. And so the SRB appealed, and thanks to the SRB, in my opinion, because if the SRB had not insisted on this fundamental point, we would not have had this decision. And what was the decision by the Court of Justice in the end? It stated, and this is one of these text-heavy slides, my apologies, but pseudonymized data are not by definition personal data. Pseudonymized data is not part of the definition of personal data, so there are two different concepts. And once again, it did not endorse the complaint of the EDPS and others that personal data should be explained in a broad manner, as otherwise the fundamental rights of the GDPR would be undermined. And well, I've mentioned already that in other clauses of the GDPR, broad interpretation is explicitly mentioned. That is happened with the concept of of controller, and it also applied, which we didn't discuss, what type of data are covered by the GDPR, such as personal opinions, and that has happened in this case as well, by the way. So there is a broad interpretation not on what constitutes personal data, or at least as opposite to non-personal data. And the court reiterates what are personal data for one entity, and hence the controller of this data might not be personal data for another down the chain, so such as Deloitte in this case. Whether they're personal data for the other, the receiver, depends on whether the receiver has, now we know that's by now, means reasonably allowing them to attribute the pseudonymized data to the data subject, such as cross-checking with other data at their disposal. Which might also be, by the way, complaints which people have made on the internet about the whole procedure. There is more to that case, and which I found a little bit more difficult to understand for its implication, as the SRB thought that it would only release anonymous data, though under a pseudonym, to another party. It had not mentioned this in its privacy statement. The Court of Justice said that it should have done so, given the purpose of the privacy statement, especially when based on consent. So this recipient should be mentioned as a recipient at the moment of data collection. Probably because the court is not so clear about that the data subjects can assess whether they trust this procedure. So read up here, whether data are re-identifiable depends. Data can be re-identifiable at A, but not at B down the line. You heard that now. To assess whether data are re-identifiable, this means likely to be used, etc. Does not mean to be absolutely non-identifiable, but the risk must be in practice insignificant. And that is standard case law now. And those data can have a pseudonym. So pseudonymized anonymous data is a viable category. But as a data source, and that is so really a new addition based on this SRB case, you should clarify that pseudonymized data may be sent to a third party, even if they would be anonymous to that third party. And though the court says, especially when the data collection is based on consent, I find it safer to extrapolate that. And there is nothing wrong with transparency, by the way. But how you do that is different, because, to be honest, I find it sometimes a little bit European newspeak. It must be concise, comprehensible, but it must also be comprehensive. So most privacy statements are not, actually. But via a layered privacy statement, you can reach more. Of course, it would be ridiculous if in all cases you must go to a privacy statement of 4 pages. You see the headlines, and when you're interested, you can click and read more. That is a layered privacy statement which EDPD wants, so that the Data Protection Board once has said that that is acceptable. Now I come to the EHDS. What does it say about that? Well, you probably know the broad lines of the EHDS, European Health Data Space, and then of course the chapter on secondary use. You can apply for anonymous data or pseudonymized data. But that's an apples and oranges comparison, because pseudonymized data can also be anonymous data. And I think that they usually are in the SPE, actually. What the EHDS means is aggregated statistical data, which must meet that absolute anonymity test, and individual level pseudonymized data, which must be analyzed in an SPE. And yeah, as a lawyer, I found it interesting that the European Commission supported the SRB in its opposition to the EDPS statement. But in this EHDS legislation, it seems to have a taken a different view because it actually juxtaposes pseudonymous data versus anonymous data. Well, both categories can overlap. And additionally, there is even something more important given the case law, that EHDS regulation explicitly forbids re-identification by the data user / researcher. So in Breyer's sense, they would already be anonymous if they are in the SPE. So my conclusion is, and some may not like this, that the EHDS regulation is sloppy on those fundamental concepts. Not that it will change anything, and neither the dapper endeavors of the TIDAS2 project, but anyhow, it is good to remember this, I think. So now get to the consequences for researchers, also outside the EHDS. Well, a little step back, but this probably you know already. You have two types of pseudonymization. The two-way, where there is a key back to the original data on which the pseudonym was based. And one way where there is no key back, so this is a safe hash usually. And the examples we have seen thus far are always about two-way. Huh? And that's also what the EHDS supposes. In Dutch health research, we often use one way. And then I dare to say that one-way pseudonymized data in an SPE, SPE is a safe processing environment, and also the EHDS has a list of requirements of that safe processing environments. It's not instituted by the EHDS, or it will get instituted then more by the EHDS, but we have them already. In the Netherlands, we have digital research environments at the most of the university hospitals. You can say that Statistic Netherlands works as an SPE. In the English literature, you see Data Safe Haven, which performs the same role. And in essence, what it does is only approved data can be analyzed there. It can be linked to other data, which could lead to re-identification. So you don't have access to the internet, for example, to what Deloitte might have been able to do, see whether people have complained about the with their name, etc., about the SRB procedure, because then it might be re-identifiable if you think that would not be excessive means for Deloitte. But you cannot do that in an SPE. And it is also safe from external and internal advisories. That is the term used in ICT safety measures. And so it must also have then probably, it's not sufficient, but it must have at least an ISO 252, etc. certification. And only the aggregated statistical results can be exported. When you have that, I think that the risk for re-identification is in practice insignificant. And so that would be pseudonymized anonymous data for the recipient researchers. With two-way pseudonymized, it gets a little bit more complicated. In principle, the same would apply, but, and there you get something ethical, that would allow for individual feedback of significant findings to the data source. And that's also part of the EHDS, actually, that you should do that. I think that in the EHDS, the concept is used very broadly, a bit too broad in my opinion, but that would require a separate webinar. And anyhow, there is also now a TIDAS document about it. But my personal opinion is research feedback should not become screening, public screening, and then not adhering to the Wilson and Younger standards of public screening. But that's my personal opinion. But I do have a bold suggestion that extrapolating then also the EAP about following subjects on their internet journey and the SRB about transparency, if that two-way pseudonymity could potentially have direct, unexpected, and still actionable consequences for the health of subjects, you should consider them personal data. And actually, when you think that you are doing such research, then you should also use two-way. But I think that's a narrow category with little real life examples. For example, if you do that 5 years after the data collection and you discover lung cancer in, for example, imaging, then you can sufficiently assume that that also has appeared already. And so that is not why you should do two-way pseudonymization. You can better work with one-way pseudonymized data. So what's now? One way in an SPE is, in my opinion, the preferred scenario, and then the recipient does not have a legal basis for the processing, between quotation marks, because processing is actually also a GDPR term, and now we don't have personal data, so you cannot use actually or formally GDPR terms. But of course, the data sender, the data source, where there's must have a legal basis, does not need a legal basis to release them, though it should be transparent. It should be, that follows from the SRB case, and it should never escape good research governance, which, going back to what I said before, that if the research has a reasonable chance then to yield such narrowly defined feedback results, individual significant findings, then you should use two-way pseudonymization. And this does not mean escaping the GDPR, because though it does not need a legal basis to release those data because they are anonymous, to process the data under a pseudonym and using also data minimization, that it's only the research data which are transferred, is further processing for research, which is allowed under the GDPR. It's not considered incompatible, but that it should be research, proper research with norms of research integrity and other aspects of good health research governance, which I cannot discuss now. But one of the aspects is that the research should then be used for the public good or public interest, as it's called in the EHDS. Another Pandora box of discussion, but you can have when is it exactly the case, but intent is clear. And public interest does not mean what a certain government thinks of is in the public interest now. Beware of that. The applicant should still explain also why feedback is not a realistic scenario when you use, at least when you propose a one-way pseudonymization. And of course, you must also explain, as an applicant, the recipient of the data or the proposed recipient of the data, that you are indeed working in an SPE, which sort of requires a data protection impact assessment, like motivation. So it does not eliminates all paperwork. And that's when you use anonymized data, you do not escape so to say, proper research governance. We, together with my colleague Daniel, we wrote a paper about that in 2020 already. And how to then, what I said before, it means that the chain is necessary. And I think you still need a data transfer agreement. Data transfer agreement doesn't say personal data transfer agreement, it says a data transfer agreement, because you must indeed assure that the data will end up in that SPE and will be used for the control for which you, the research for which you were asked. You must be transparent to your participants, and with cohorts, with volunteers, it must be compatible with the original consent, that you can sort of convey that to the participants. And I think it can be a generic, broad procedure. You should, as when you have a cohort with volunteers, you should interact with them anyhow. Otherwise, no. That is what we call then in the HE project participant-facing governance. But now, and what I skipped earlier, a vexing question about the consent modality. Is there a consent modality necessary when you use data from electronic health records, just from hospitals? Like I mentioned, with cohorts with volunteers, you can explain that in ongoing context. And that is then part of the transparency. You do not have to ask explicit consent anymore. For secondary use of health data, there is has of course been lots of discussion, and my personal view has always been informed consent doesn't work, or it is when you want it to work, like they have done in Germany, it is very costly. It should be opt out. So now that will now also be the law under the GDPR, or under the EHDS, excuse me. Member states must implement a generic opt-out under the EHDS. But the EHDS will not be a straitjacket. Research outside the EHDS remains possible. Now, and originally it was then consent or anonymized. Now we have now seen that one way pseudonymized data in an SPE is anonymous. So now can you bypass the consent if consent was the legal basis usually in your country? I think that has become a moot discussion, actually. You cannot have two systems. The opt-out in the EHDS for secondary use, and then nothing for pseudonymized anonymous for the same data and the same, in broad terms, same type of research without the EHDS. That is unexplainable. Once people ask me, well, what, you have different concepts, but can you explain it on the market? If you can't explain it on the market, then you shouldn't try it even. Other way around doesn't work, by the way. If you can explain something on the market, it doesn't mean that it is good, but at least you must be able to explain it. And so, yeah, opt-out should be the generic rule also for these pseudonymized anonymous data from EHRs. Like I mentioned, with cohort for volunteers, it is much more easy. And that claws back on present practices. For example, I have defended in our Dutch Code of Conduct on Health Research that pseudonymized anonymous ELD data were did not fall under our present Dutch consent modalities. I'm afraid I have to come back to that, given the ECR, which has now this system. And a suggestion to member states which still have consent as the base modality, change that also for research outside the EHDS to opt out. So is there very little wrong with the SRB decision? No, there is still advantages. Pseudonymized anonymous saves red tape. The joint controller agreement or controller agreement is not necessary. The recipient does not need a legal basis for cohort studies. It makes things much easier. And also countries which state, like we had in HEAP, that research data should be analyzed within their borders, have even less arguments against this ban, because you do not release personal data under this pseudonymized in an SPE construction. So I come to the conclusions. Well, the first two are, you know by now. But then the third bullet, when to use that approach depends on the interest of the persons at the data source. It should always be used for the public good or public interest, and it does not escape research governance. Opt-out should be introduced over the broad range. You cannot escape opt-out also outside the EHDS. That is a ridiculous construction. But it does serve certain issues for cohorts with volunteers. And I think that was it. Thank you for your attention.
Thank you very much, Evert Ben. This has been a fantastic presentation, and thank you very much for shedding light on how to best use data, treat data, and exchange data as we move forward. There are many questions, so let's make absolutely sure that if the people want to contact you, they will be provided with your email address, but it will be done on a private consultancy basis. So this is not going to be part of the project. Also, we want to make sure that if people want to join the international Human Exposome Network, they will be provided with a website address, so they can always join the newsletter for the Human Exposome Network. And to make sure that, sorry, the camera had an issue, to make sure that the questions have been recorded. So we will create a list of these questions for future use, but not by Everett Ben to respond to all of them at the current time. I don't know, have I said it right, Everett Ben?
You're correct, yeah.
Okay. So we have 5 minutes if you want to respond to one or two of the questions. Yes. There is a question by Marit Cruz. If the source is holding pseudonymized data as personal data and will make it accessible as non-personal data, does the source still need a legal basis, like the SRB had the obligation to inform under the GDPR?
Well, yeah, so and the information is not is part of your obligation under the GDPR, but is formally not a legal basis. You must have a legal basis first, and then you must inform the data subjects about your legal basis, etc., and what you are going to do with the data. And that was what, according to the court, the SRB hadn't done, or hadn't done properly. And so if you make data available to a third party in your own digital research environment, then you should have, or you should warn your patients that you are doing that. And that is the essence of the court decision. And yes, and then my take on it is that given that it does not escape the consent modality which we have at the moment, so it means that actually you must also have a legal basis. Yes, and I hoped I had come to another conclusion, but I'm not I'm more conservative now than I originally was. You must indeed have a legal basis to make those data available, which can be the consent or it can be opt-out. That depends on national law.
Thank you very much, Everton. Maybe in the last 5 minutes, one final question. So the question is, if the receiver labels the data as anonymous, as they do not have access to the key, wouldn't that, in other hands, or even made public, would bring harm and risk for the original data subject?
Well, so if the recipient can get to the key and reverse it, so to say, then it are not anonymous data. And how he can do that, then so that is then if there is a significant risk to reverse that phrase, that he can do that by the with the of whether he can if he can do that without excessive means, then yeah, the key or the hash is not sufficiently secure and it will be personal data apart from the data which are under the key, because those data can also be re-identifiable. But that's why we have that SPE where you cannot do that. But if you release data not to another party which is not, or not in SPE, I didn't discuss that, then you must assess whether the key is safe and whether the data under the P are not re-identifiable. So, and then if you combine data from different sources under the P, then you get a richer data set for the same individual. So then it might even be more re-identifiable. Again, in an SPE, I don't see that danger, but outside an SPE, those are always concerns.
Excellent. Thank you very much, Everton. This concludes the current webinar. I would like to thank everybody very much for logging in. I would like to thank very much Everton for his wisdom, for his patience, for all the work he's done for HEAP and setting the foundation for the Exposome studies. Thank you all very much for watching, and we'll meet in the next webinar under the International Human Exposome Network webinar series. Thank you very much.
Thank
Bye-bye.
you.